Welcome back, everybody. Will Worsham joins us now for this week's Speaking Legal discussion, where he answers one of your legal questions right here on the air. Welcome.
Thanks. Welcome. Good to see you again.
Thank you.
All right, here we go. Here's the question. My sister's been living in our mother's house for free since our mother passed away in January of 2013. The house was left to both of us as inheritance. The attorney my sister hired has not sent me any paperwork or my half of the money, nor has my sister. Am I able to demand rent or some form of payment?
Yeah, well, this is an interesting question, and I kind of would almost like to back up like I usually do and say I'm interested in how this inheritance went about. I mean, there's a couple of different ways it could have gone. It could have gone through probate, it could have gone with a will, it could have been in a trust, it could have been as part of a beneficiary deed. But let's just start from the assumption that there's not any probate problems, there's not anything like that.
It's a done deal, it was left to
Right,
yeah,
we've got a house. Well, if you own a house, even if you own part of it, you have a right to live in it. So the sister has every right to live in that house. So I'm not sure that the we'll say non-custodial sister in this situation really has a claim directly against her for specific rent, because there's no contract. They're probably going to need to sit down and probably negotiate that out. So the question is then, how do you do that? Maybe a sister says, well, I'm just not going to pay you, right?
Yeah.
So that's kind of a problem. As I'm going to assume once again that the sisters own this property in what's called tenants in common. That means they both have an interest in the property, and I'm going to assume for purposes here we're talking 50-50. Any tenant in common has the right to what's called partition and sale. They can file a lawsuit, get a court order to sell the property and divide the proceeds. Usually that might be what we would consider a nuclear option. You don't necessarily want to do that, but it does at least force the other party to the negotiating table to say, okay, if you want to live in this house, you need to pay rent. Obviously, if you own half of it, you wouldn't have to pay half of it. But that gives you a little bit of strength in a bargaining position to just say, listen, if we can't come to terms on this, I'm just going to sell the house and get half the money.
In something like this, isn't there usually, I don't know if the word is right, a conservator, someone who oversees?
Right.
Can you
trustee,
not?
someone.
A trustee, someone who can make that decision?
Yeah, well, there should have been either an executor of a will or a trustee. But if we're past that point, if the assets of the estate or trust have already been distributed, then that person is no longer in authority. Theoretically, at some point, if the grandmother passed in January, let's say January 2013, and the sister was living there, there would have been an executor in place at that time, unless this was transferred by beneficiary deed, which is, there is no executor. That's one of the benefits of using a beneficiary deed. You don't have to go through probate and all those types of things.
Well, at some point you wonder too, were both names put on that house? What happens at tax time with personal property? What if there is an injury or some form of liability? Is the sibling who's outside the house saying, look, I can get dragged into anything here?
Yeah, all those are great questions, and we can go to the next block.
Take all week.
Talking about all these things.
A lot of
and frankly, maybe someday we should, but those are actually all things that really do need to be discussed, and it goes back to my original question. If this was via beneficiary deed, maybe they've never actually transferred the title. Which you don't necessarily have to, but it's certainly a good idea to come in and make sure that the titles are correct with the correct owners.
Could you sell your interest in that house?
In a beneficiary deed?
Well, if just as it sits, as the question sits, we both own the house.
Right.
Could I sell my interest in the house and say, fine, you guys take it, I'm out of here?
Yes, you can. Yeah, you have an interest that you can sell as a tenant in common. In fact, realistically, one of the great answers to this solution is for one sister to sell the other sister her interest in the house. They're consolidated and you're done.
That's a good way to look at it. All right, if you have a question for Will, you email him at wworsham@color10.com. He'll answer your question right here on the show. Thanks so much.
Will.
You're welcome.
All right, coming up, Grove Spa.